One of the questions I get asked probably more than any other is, does Amber Heard have a chance on appeal? What's she going to argue? Let's talk about it. So right out the gate, I want to assure you that this is not going to be a video where I lay out a bunch of law and legal research to support or disprove arguments that I think Amber Heard might be making on appeal. I am not here to do her legal team's job. So that's not what this video is going to be about. Instead, it's really going to be about appeal strategy, about how do you tell a good issue on appeal from a bad issue on appeal. And so then based on that, we'll be able to look at the types of options she has available. And from there, we can see, is this likely to be successful or not, depending on the types of choices that she ends up making. So the first thing to look at when asking if an appeal argument is strong or weak is this argument focused on the facts or is this argument focused on the law? The reason why this is a very important distinction is because the appeal process is not a relitigation of the verdict. The Court of Appeals is not going to be asking, do we agree with the jury? Do we think the jury found the right people credible? Do we think the jury properly evaluated the evidence? That is not their role. The Court of Appeals recognizes that they are miles away, they are months down the road, they're reading a cold, dry transcript. It was the jury who sat there in the box while the case was put on and are in the best position to be able to evaluate the shit show that they observed and to make sense out of what was presented to them as evidence. And so the Court of Appeals respects that superior position that is inherent in the function of the jury to be the ones who are there observing in real time and making those critical, factual types of judgments about who do we believe is telling the truth and who do we not. So to the extent that Amber Heard is hoping that this appeal is going to relitigate the fact of her being found to be a liar about Johnny Depp abusing her, the fact that calling her accusations a hoax is not a lie, well, then she's already lost because that is not going to be a viable strategy on appeal. It's not something that the Court of Appeals would even entertain. So for their purposes, as long as there is evidence in the record that if the jury believed it, it would be enough to support the cause of action that they've returned the verdict on, that's going to be enough. If there's a fair process and legally sufficient evidence, then that verdict is going to stand. So very first question then, easy to work through. Are we talking about facts? Are we talking about law? So now if we narrow that down, we'll take the facts out of the question. Somehow the law firm is able to convince Amber, we're not going to be relitigating you lying about Johnny abusing him. We're not going to be, making your new case for that. Then what are we going to be focusing on? So when we look at legal issues, rulings that were made that produced this outcome, the next thing that you look at is what type of ruling was it? And the reason why this matters is because there are different standards of review for different types of legal rulings. Some legal rulings are the judge going through and interpreting what does the law require in order to then be able to evaluate how does that apply in this particular case. So an example of that kind of legal ruling, question of law that's presented to the court. A good example of that was the argument that Elaine Bredehoft was so proud of, her argument that the UK judgment precluded having a separate trial in Virginia. And so you can see, if you read through that opinion that Judge Azcarate issued, it was in August of 2021, that what that argument required her to do was to go through and evaluate what is the law in Virginia dealing with preclusive judgments. This was kind of an arcane legal issue, I suppose. It takes a special person to like talking about things like res judicata and collateral estoppel. I don't want to get too into the details about the merits of these arguments. I did discuss them at great length on Twitter. And I suppose if people have a great interest in that issue, I can make a video about it. But for our purposes here, the point is simply that she had to go through and make a decision about what does Virginia law allow, what does Virginia law require when a person is trying to assert a judgment from another jurisdiction and say, hey, they already had their bite at the apple, they shouldn't have an opportunity for a new trial. The reason why those types of legal issues are some of the best ones that you can present on appeal is because they have the least deferential standard of review. The standard of review of interpretations of the law is called de novo. And so what that means is that the Court of Appeals now is not in a worse position than the trial court was. They're arguably in a better position because they are literally just spending their days researching the law, trying to evaluate what it means, making decisions about it. They don't have this complication of having to try to preside over trials and stuff in the meantime. So they are just as equipped to research and understand the law as the trial court is. So they don't give deference to the trial court's interpretation of laws. They will decide for themselves, hence de novo. So it's always good when you can find a de novo issue because it basically means you can scratch out, in large part, whatever the trial court said before. It's not a bad starting point in terms of how to frame your argument, but you're going to be able to speak to a blank slate to try to get the Court of Appeals on board with your interpretation of the law. And they're not going to start from a standing point that the trial court got it right. So very advantageous position to have. The other type of legal decision that gets made are discretionary decisions. These typically have to do with things like whether evidence is admitted, how the courtroom proceedings are going to be conducted, things along those lines. And the reason why those are considered discretionary is because they have to be flexible. Every case is somewhat unique. And so you can have like general rules of evidence, but how that applies in any particular situation is going to be very complex. A piece of evidence that is offered in one case by one person to prove one thing is potentially not going to be admissible if it's presented by a different person, offered for a different reason. So these types of details really matter when it comes down to making those types of judgments. So in that situation where the trial court is entrusted with the responsibility of overseeing the conduct of the trial, the courtroom, all of those types of details, they get much more respect. The Court of Appeals is going to start from the standing point that this was a decision that was within their discretion to make. So unless you can show me that it was extremely unreasonable for them to take the decision that they did, then we're going to just go ahead and defer to the trial court as the one with the responsibility to make those types of decisions. We know at least from the public statements that Amber Heard and her lawyer made, that Amber is dying to, relitigate her complicity. She's got new claims of evidence that didn't come in. She's made all these suggestions that she tried to get evidence in that was excluded. She even made comments about it during the trial, that there was, stuff that she would love to show the jury but can't. So these are potentially viable issues in the sense that, yeah, if Judge Azcarate made a ruling excluding her evidence, and Judge Azcarate's ruling was not reasonable for one reason or another, it misapplied the law. She didn't understand what Amber was trying to do with the evidence. She didn't understand the purpose for which it was being offered. I mean, there's a variety of reasons in which a judge can mess up an evidentiary ruling. And so if they could show, hey, this piece of evidence should have been allowed, that is a viable appeal argument. They would then still have to show, had that evidence been allowed, it was a game changer. It had a realistic likelihood of shifting the way that the jury saw, this entire case, this entire relationship. So in that sense, the bar is extremely high on evidentiary errors. So the third thing that matters when you're evaluating the strength of an appeal argument is, did this come up in the trial court? The reason why is because we don't want to have a system where parties can just sandbag each other and the trial court and hold all of their good arguments for why the other side's case failed until they've gotten a chance to win on trial, and then, have this backup plan of raising these issues on appeal. That is not efficient, is not a good use of the system. And so because of that, there's a pretty firm rule that if you haven't already made this argument to the trial judge, you have waived it for purposes of appeal. And so it's literally just a disincentive to, try to hold issues in your pocket. There are very, very, very few, very narrow exceptions to this rule. So that narrows things down for us significantly, because we know now that the only possible arguments that she can make are arguments that she already asked Judge Azcarate to rule on. She's not going to be able to spin up some entirely new legal theory, for why his case should fail. Now, having said that, there is some gray area around the edges. You don't necessarily have to, use exactly the same words, cite the same cases. But by and large, if the trial judge would not have known that you wanted a ruling on this particular issue based on what you presented in the trial court, then chances are pretty good the Court of Appeals is not going to consider that issue. So based on that, where that leaves us with the options for Amber Heard to pursue an appeal that is as strong as it could be, she's got to look at the legal rulings that were made. So we have some obvious options here. There were three pretrial rulings that she can contest, where she tried to get Johnny Depp's case, thrown out. They had motions that were made during the trial. They had motions in limine that dealt with admitting and excluding evidence. Motions in limine are kind of a weird middle ground because sometimes they're considered final rulings and sometimes they aren't. Sometimes they're just intended to kind of give you a guideline for going into trial, but nothing is necessarily final until we see how everything fleshes out. So motions in limine can be a little bit tricky. But in general, rulings admitting or excluding evidence, those are viable. And then, of course, we had these halftime motions that they made to dismiss, as well as the post-trial motions that they made to dismiss. So all of these are going to be potential arguments that have been preserved for the appeal. The last thing that often factors into a decision about what issues to raise on appeal that doesn't necessarily affect whether you're going to win or not, but nevertheless gets taken into account, is the potential for this issue to open up doors for further review. And what I mean by that is that, by and large, the Court of Appeals of Virginia is going to have the final say on these particular legal questions that get presented to it. But there are other courts that either party can ask to review the Court of Appeals' decision as a matter of discretion. The Virginia Supreme Court can take a look at it, and potentially, if they raise First Amendment issues, then the U.S. Supreme Court would be a potential avenue as well. The reason for that is because the U.S. Supreme Court is the ultimate decision maker on questions concerning, the federal Constitution. So there is a justification for them to take an interest in rulings that are made about the First Amendment, and particularly in a high-profile case that gets a lot of attention. That can be a reason for them to decide, hey, if the law needs clarified in some way, if there's some development that needs to be done with, certain parts of the jurisprudence, then we may be interested in taking that case up. So, because the Virginia Supreme Court and the U.S. Supreme Court are courts of discretion, meaning they don't have to take your case, they take an extremely small percentage of the cases that they're asked to take, then that means that if you want those courts to take up your case, you need to present it in a way that is going to make it look like the kind of case that they want to take. And so with the U.S. Supreme Court, for example, they're typically looking at things like, is there a conflict in the law between different circuit courts on a particular issue that we as the final decision maker need to address to resolve that conflict? They can look at issues where the law has developed in a way that perhaps is, no longer compelling to them. There's been a lot of buzz about First Amendment jurisprudence, the actual malice standard lately, because two Supreme Court justices have kind of gone on record indicating that they think maybe that standard needs to be revisited. Actual malice isn't written in the Constitution. It's essentially a policy that was created by judges. So in a situation where there's a known issue like that, where there's a potential for movement in the law based on the configuration of the court, that can be another basis for choosing certain issues to pursue because you think that court might be interested in your case as a vehicle to achieve that change in the law. So when we apply these standards to the record of the Depp versus Heard case that we have available, the answer to the question, could Amber Heard win her appeal, is yes, she could. It is not impossible. She has preserved arguments on legal questions that will be reviewed independently by appellate courts to decide if they agree with Judge Azcarati's interpretation of the law. Those are the types of issues that are most likely to win on appeal. They tend to be the strongest. They've also got potential arguments that may go to some instability in the First Amendment law that higher courts may be interested in taking up and reviewing. So, like I said at the outset, my goal here is not to go through an exhaustive legal analysis of the arguments. There will be plenty of time to do that when they file their briefs. Incidentally, the record has been filed in the Court of Appeals, so there is a deadline now for the briefs to be filed. It's November the 2nd. It is possible that that deadline is going to be extended. It's not uncommon at all. So don't be surprised if that happens. I will be following it, though, and we'll be planning to talk about the appeal arguments when the briefs are filed. Anyway, my goal here is not to go through that process now, but I do want at the same time to offer some assurance that yes, I have looked in detail at a lot of these legal issues. I've done a lot of the research. So my personal opinion is that it's going to be very unlikely for any of those things to happen. But it's not impossible for the type of black swan event where, the courts have just been waiting to resolve a conflict in the law that just happens to be line up with the position that Amber Heard wants the court to take. These things do happen. So I can't rule out the possibility that she would possibly win her appeal. She does have issues that she can present. But she's got to employ an intelligent strategy in how she selects those issues, meaning she needs to listen to her goddamn lawyer and not, follow her own impulses in what she would like this appeal process to be. But they still have the hurdle to get over of just because you've got a legal argument doesn't mean you have a winning one. They got to show that Judge Azcarate got the law wrong, and it doesn't take a lot of work. Well, it does, but it's not that difficult to go back and read Judge Azcarate's rulings, look at the basis for them, and see that they are pretty thoroughly researched, clearly reasoned, and going to be difficult to challenge. So for that reason, I don't expect she will win her appeal, but time is going to tell, and I will be here to watch. Thank you for joining me. I will see you in the next one.